It is November 27th. I wanted to provide a quick update. Earlier this week, the United States Supreme Court uh, placed a preliminary injunction on COVID restrictions that were in place in the state of New York. And I think there may be some implications here nationwide, especially for the state of Michigan. So just wanted to briefly talk about what happened and what's that look like for the state of Michigan going forward. So I guess to start, what were the executive decrees? What were they? I don't know all the details, but I do know that there were zones that were created, and if you were in a red zone for churches, they put a gathering limit of 10 people. And if you were in an orange zone, it was a little less restrictive, but still extremely restrictive. There was a limit of 25 people. So I'd like to show real quick, this is the statement that the Supreme Court put out. This is their decision, and this is Justice Gorsuch. I just want to read a section here of the decision that this injunction needed to go in place. So he says, at the same time, the governor has chosen to impose no capacity restrictions on certain businesses he considers quote unquote essential. And it turns out the businesses the governor considers essential include hardware stores, acupuncturists, and liquor stores. Bicycle repair shops, certain signage companies, accountants, lawyers, and insurance agents are all essential too. So, at least according to the governor, it may be unsafe to go to church, but it's always fine to pick up another bottle of wine, shop for a new bike, or spend the afternoon exploring your distal points and meridians. Who knew public health would so perfectly align with secular convenience? I think Justice Gorsuch hit the nail on the head for many people who have been trying to figure out how these orders are constitutional. And I think it's worth exploring a little bit in a little more in depth as to where he's coming to this conclusion from. I think it's best to start with, what does the First Amendment actually say? So here we have, this is the Bill of Rights, and I have highlighted here the First Amendment. And I'll just read the first opening part here, because the first part of this sentence that's relevant for this discussion. It says, Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. Well, very interesting. We have the word no here, so Congress shall make no law. And it says it can't prohibit the free exercise of religion. So what we have is what judges will do is they'll interpret what's called strict scrutiny. If there's going to be something in place that somehow infringes on these fundamental rights that we have in the First Amendment or in the Constitution anywhere, it'll have strict scrutiny. So there's a three-part test that judges will look at. The first is there has to be a compelling state interest. The next, it has to be narrowly tailored. And the third is it has to have the least restrictive means possible. So I think what Justice Gorsuch here, he's sending a message to these governors. Look, if you have your bicycle shops open, if you can go to a liquor store, this is not least restrictive. This is not narrowly tailored to close down the churches. This just fundamentally is unconstitutional. So what's this mean for the state of Michigan? I think it's very impactful, especially in regard to statements that Governor Whitmer made last week. So last week, Governor Whitmer said that she still has the authority for a stay-at-home order. I'm not making this up. It's very public. This is the U.S. News, and she basically says she still has the authority to issue a second stay-at-home order. This, despite the fact that, as we all know, a month and a half ago, the governor had a very big loss at the state Supreme Court, saying that her use of the 1945 Act was, in fact, unconstitutional. So what does all this mean for the state of Michigan? I think it's important to keep in mind, after this really big loss that Governor Whitmer had in the Michigan Supreme Court, she's still under the impression that she has the authority to write and enforce laws, which, as we can read through the Supreme Court decision, the Michigan Supreme Court decision a month and a half ago, The executive does not have the authority to write laws. This is a violation of what's called the non-delegation doctrine. The legislature cannot delegate its authority to write laws to an executive on this type of scale. There is a process for writing administrative rules and things like that, but it's not just a clear handover of authority. So I really think Governor Whitmer may want to maybe get a different legal team. That's maybe what I would do if I had a legal team that gave me advice that had such a devastating loss. I would think twice about following what their advice would be again, because the Supreme Court is sending a very strong signal here. Your COVID restrictions need to be in line with what is authorized in the United States Constitution. And I don't think a blanket stay-at-home order, restrictions on churches, or other types of activities like how many people you can have in your house, I don't think that those are going to pass strict scrutiny. And I do think that there are some changes that are coming around the corner nationwide. So just wanted to provide this little update. Thank you for your time, and God bless.